Okay, this is Larry McGee again, back for the fourth in our series on the buyer listing contract. We'll cover a few more sections with this video. We'll start with video 13, or section 13. But before we do that, let me again make a disclosure for anyone who's seeing this who is not employed by or contracted to the Berkshire Group. These videos are for the exclusive use of agents that are employed or contracted by the Berkshire Group. My suggestion is for any other people, you need to obtain the advice of your employing broker. With that said, we'll talk about Section 13 of this contract, disclosure of buyer's identity. Broker does or does not have permission to disclose buyer's identity to third parties without prior written consent of buyer. I think we're going to check does in almost all cases. It's pretty obvious if we create a proposal, a contract proposal, an offer, that the seller is going to know the buyer's names. So it's very difficult not to disclose the buyer's identity. Certainly we don't want to be doing that prior to the actual creation of an offer. There's really no need to discuss our clients with anyone until such time as we have a written offer. Now there may be occasions where you want to talk to the listing agent, the selling agent, about some particular circumstances regarding the assembly of your contract offer. However, there's no reason to disclose your buyer's particulars. There is the occasion where the buyer does not want their identity disclosed. Certain people of celebrity status, obviously, there's occasions where corporations may be wanting to purchase property for an assemblage. A variety of reasons where the identity certainly is not something that the buyer wants known to either the sellers or the general public. The big case in point that comes to mind is the Disney assemblage of all the land south of Orlando for Disney World. They assembled most of that land for a 2 or 3 year period without anybody really knowing exactly what was going to happen there. Had anyone found out prior to Disney assembling that property, obviously property values would have gone very high before they were able to execute their purchases and options. Certainly the case of a celebrity where somebody, they've just got a lot of status, they don't want people to know that it's them that's buying a house. I think in that case, the way you handle that is we work through a straw buyer. The buyer appoints their attorney or somebody that will act as their attorney, in fact, to actually purchase the property. We could say in the contract that the contract would be assignable, or it could be purchased, closed, and assigned to a trust at some point after that. There's a variety of ways to do that. If you run into somebody that has that kind of status and financial capability, they'll probably have an attorney who's more than capable of figuring out the best way to advance an offer. Number 14, disclosure of settlement service costs. Buyer acknowledges the cost, quality, extent of service vary between different settlement service providers. These various folks, known as attorneys, lenders, inspectors, all these folks are covered by the RESPA laws enforced today by the Consumer Finance Protection Bureau. Obviously, there's differences in costs. It's important that we make sure our consumers are aware that they have a variety of options to choose. Those options are shown in our buyer orientation book. In the back of the book, there's a section on settlement service providers, including title companies and lenders. The consumer certainly has a right to choose the folks they want to close this transaction for them. Non-discrimination. Parties agree not to discriminate unlawfully against any prospective seller for any reason. As far as I'm concerned, the only reason we would ever discriminate against anyone is because they didn't have the money to buy something. That's it. Anything else, whether it's listed here as protected by various parts of the United States Code or not, in my mind, it's just good business sense to help people get done what they need to get done. Discrimination really doesn't serve anyone, so unless they don't have any money, can't afford to buy something, we shouldn't be discriminating. Number 16, recommendation of legal and tax counsel. By signing this document, buyer acknowledges that brokers advise this document has important legal consequences. That's stated right up at the beginning of the contract. Make sure that our consumers are aware that if they want to seek legal counsel, they're certainly welcome to do so. Although attorneys are not required in a real estate transaction in Colorado, there are some consumers that feel comfortable in having an attorney review contracts. We should understand that, make sure that they have the opportunity to do that. Mediation, it does happen, especially with earnest money. If a dispute arises related to this buyer listing contract and is not resolved, parties must proceed in good faith to submit the matter to mediation. Now, on a buyer listing contract like this, the only reason I could think of that we'd probably have a mediation issue is if we collected an amount up front. The prospective buyer complained that we overcharged in some way. We unfairly cost them money in some way for some failure to act. That certainly is possible. By and large, most consumers just want to buy a house. And if we're helping them buy a house and doing our job properly, this is not a contract where we're going to see mediation as a common event. Attorney fees, number 18. In the event of any arbitration or litigation, the arbitrator or court must award to the prevailing party all reasonable costs and expenses, including attorney and legal fees. This is really simply a direction to the court that says that if there is a dispute, that the prevailing party is going to have their costs paid for. I think in general, we certainly don't want to be getting into disputes over buyer listing contracts. If we have an unhappy consumer, if our client doesn't like us anymore, let the client go, wish them well, and get away from them. There's really no point in trying to make a consumer miserable because we have a contract. It doesn't really mean that much. Okay, before we wrap up with the next section, we'll just stop here at 18 before we get into additional provisions. We'll have a few comments there. So we'll be back again with the next section on the buyer listing contract. Thank you.